Hi, I could certainly understand if you are unsure about who to vote for in the upcoming Redmond City Council election. Last year, the Redmond City Council passed some legislation that had some unintended consequences that impacted me and my property directly. Because of that, I spent some time reviewing public video recordings of the City Council sessions. What I discovered was quite concerning, and it made me realize that it's important that we cast our votes correctly to ensure that we have the most qualified statesmen and stateswomen in these positions. From what I learned, I feel that with one exception, we do need to have more qualified people on the Redmond City Council. Before we get into the details, I'll need to provide some background information. First, there's the federal law, then state law, then county or city law. Each has to work within the confines of the laws above it. For example, the federal law has a contract clause that states, no state may pass a law impairing the obligation of contracts. This is in the federal Constitution. The state of Washington's Constitution has pretty much the same law. Here it says, no bill of attainder ex post facto law or law impairing the obligations of contracts shall ever be passed. So that's the first piece of background information. The Washington state law has some more RCWs concerning conflict of interest. Here's a section on its purpose. It's the purpose and intent of this chapter to revise and make uniform the laws of the state concerning the transaction of business by municipal officers. Further down in the section, they define the terms contract and municipal officer. So municipal officer shall include all elected and appointed officers of a municipality, together with all deputies and assistants of such an officer. And contract shall include any contract sale or lease or purchase. In this section, they state no municipal officer shall be beneficially interested, directly or indirectly, in any contract. And in this clause, they describe some of the exceptions. A municipal officer is not interested in a contract if the officer has only a remote interest in the contract and the extent of the interest is disclosed to the governing body of the municipality of which the officer is an officer and noted in the official minutes or similar records of the municipality prior to the formation of the contract. He also mentioned that the municipality must ratify the contract in good faith by the vote of its membership, sufficient for the purpose, without counting the vote or votes of the officer having a remote interest. So basically, this means that if the officer has any kind of interest in a contract, it's either remote or it's not remote. If it is remote, they must disclose it to the municipality and they must recuse themselves from the vote and they must not attempt to influence any other officer in the municipality for that vote. All right, so to summarize this, no state may pass a law impairing the obligation of contracts, includes municipal ordinances. And obviously the reason for this is because if various counties and cities and states were always changing people's contracts, it would be very difficult to get any business done. There would be no certainty around a contract if you didn't know in the future if that contract would still be valid. So they're basically trying to say government should not be messing with business once a contract has been established within the rules of law. And secondly, the chapter on conflict of interest is trying to make it clear that if you're putting your hand on the scale because you have an interest in a contract, that is not in the best interests of society. We want impartial decision makers involved in the process of making legislation. We don't want people to be voting because they would personally benefit from the outcome of the vote were it to go one way or another. And to that end, anybody who is in a contract and who might benefit from the legislation needs to declare there's a conflict of interest and needs to recuse himself from the process of making the decision. This should be obvious to anybody in politics. Both these are very well understood legal concepts. The next chapter is RCW 35.21.830. And this one's a little bit less well known, but I think anybody who is working on legislation in this area should be familiar with this particular piece of legislation. It states that controls on the rent of residential structures is prohibited with certain exceptions. It states the imposition of controls on rent is of statewide significance and is preempted by the state. In other words, it's the business of the state to figure out what the rules are and to provide a consistent set of rules across the state so that tenants and landlords alike have one place to go to for the rules they must follow, and they don't have to become familiar with different rules in different cities and counties in addition to the rules of the state. They go on to say no city or town of any class may enact, maintain, or enforce ordinances or other provisions which regulate the amount of rent to be charged for single family or multi-unit residential rental structures. Now, the exceptions relate to properties that are under public ownership, public management, but not individual or companies' properties. So back around 2021, inflation really started to pick up, as you can see from this graph, and that continued through 2022. But more importantly, perhaps, is that King County started raising people's property taxes or raised their assessments at unprecedented levels of 30 to 40%. As you can see from this graph, this occurred in 2022 and 2023. So these increases in costs and increases in property taxes put homeowners in a situation where they had to pass those expenses on to their tenants. However, at the same time, the city of Redmond passed an ordinance to try to prevent these rent increases from occurring, or at least to forestall them as much as possible. So this is the city ordinance that they created. They adopted it on July 18th of 2022. And what this ordinance basically said was that you couldn't raise the rent unless you gave 120 or 180 days notice. I made a graph to show what this looks like. The rules for the state of Washington are that you have to give 60 days notice of a rent increase. But the city of Redmond's ordinance differs from the state law. It says that you also have to give 120 days notice for a rent increase between 3 and 10%, and 180-day notice for a rent increase that's greater than 10%. Now, obviously, after the factoring in inflation and the property tax increases, most homeowners had to raise the rent by more than 10%. But this new ordinance basically prohibited them from raising the rent for a period of half a year or 180 days. This is in contradiction to the state law that said only 60 days notice is required for a rent increase. So now I wanted to share with you some of the discussions that occurred in the city council, both before the ordinance was voted on and afterwards, as they did a follow-up discussion about the effects of the ordinance.
To clarify this is, we're talking about new leases because we wouldn't have control over current leases. Is that correct? And so what would happen would be, I'm just trying to make sure I talk through what will occur, is if this passes in 5 days, then any lease that day would need to meet these terms? Is that correct?
Director? So, I actually would like to hear Mr. Haney's response to this question, because the notice provisions are deemed to be included in leases. So I don't know, generally in land use, things can't be retroactive. I don't know the answer to that question.
The ordinance as drafted would apply to all new leases and all current leases. So the leases are deemed to include these provisions.
Limiting
I
that
would
will be
say
interesting.
that generally speaking, city ordinances are not retroactive. They do not undo things that have already been done. They prevent acts and regulate acts that are undertaken in the future. You can regulate existing tenant relationships as long as you are not in conflict with state law.
And this is one such case, just to clarify that.
My understanding is that that's the intent of this ordinance, and I don't see anything in this ordinance that specifically and directly conflicts with the State Landlord-Tenant Act, which is what's necessary in order for it to be illegal to do this.
Okay, so in reality, in 5 days, all of the leases in Redmond will be subject to new terms and conditions, and theoretically, many of those will be non-compliant. Wow.
If that is the case, Mr. Carson, I think, raised a good point in terms of what the intent of that language was.
The state of Washington has over the years come up with a good set of laws and regulations that govern landlord-tenant relationships. These are well documented and everybody can find them. And in those regulations, it says that the imposition of controls on rent is of statewide significance and is preempted by the state. No city or town of any class may enact, maintain, or enforce ordinances or other provisions which regulate the amount of rent to be charged. Now, if you're a landlord or a tenant and you read the Washington laws, this is a pretty clear message to you that you do not need to go looking for additional ordinances created by the cities and the county to tell you what you can and cannot do with returns in terms of a landlord-tenant relationship. And knowing there's one set of cohesive laws is very good because it makes it easier for a landlord or a tenant to be on top of the rules. And this helps govern the relationships and it takes risk out of the relationship. On the other hand, if you have to try to figure out how all the different ordinances from different counties and cities interact or interplay with the state law, and if you get it wrong, you could end up on the wrong side of a dispute in a legal situation or a civil matter, and that could be costly or expensive, and it can add a lot of risk to a tenant or a landlord who wants to just simply resolve a dispute. Now, if you're wondering what the intent of the Redmond City Council was, I think it's pretty clear that the intent of several of the council members is to regulate rents because of some of the statements they've said.
Has not been brought forward as a major form of action until now. So I'm truly grateful for this opportunity to take that first step in protecting our tenants and really just making sure that Redmond is livable for everyone and that no one is forced to leave the city of Redmond or cannot come into the city of Redmond simply due to the high cost of rent.
Councilmember Carson?
Thank you. So I won't be supporting this, and it's not because there are provisions in it that I don't agree with, but there are many that I do. But it's because of the process that we've undertaken. It's been been very rushed. We have not done the kind of outreach that we would typically do on something this important. And I hate to say this, but mark my words, this will be coming back to the council for amending because we've gotten something wrong and there will be an unintended consequence. And I can't support even good intentions with bad process behind it. So I can't support it. Thank you.
Councilmember Fields?
So I think this is an important ordinance before us, and I will be supporting it. I understand somewhat Councilmember Carson's concerns, but I think a lot of us have actually done a lot of research on this issue, and we've heard from the public either through public testimony here on the dais or in emails or in personal conversations. I think that we have gathered the information for what we're doing tonight, which is, as I've said a few times, extending common sense protections for tenants beyond what the state currently offers. I would like to say also this again, this does not solve the affordability problem. This mitigates part of the symptoms of that problem. I am not comfortable with calling this a first step. If we are going to look into the affordability problem, we need to do what Councilmember Carson has described and then some. We need both the landlords and the tenants and the entire community to be involved in that discussion. If we're going to take steps to actually change the dynamics of affordability, that is a big, big issue. We are not, I repeat, we are not doing that tonight.
So here we heard Varisha Khan say that she was interested in making sure that nobody was forced to leave or couldn't come to the city of Redmond because of high rents, which implies that they're really trying to control rents. And we also heard Councilmember Steve Fields talk about addressing the symptoms of the affordability problem and changing the dynamics of affordability in his remarks to the city council.
All right, I don't see any more hands. This is a roll call vote to approve the, I'm going to say it correctly, the ordinance as amended with the social security number stipulation. And that was the only passed amendment. Starting with Council President Forsyth.
Aye.
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 And that passes 6-1. Thank you all for the discussion.
So that was the vote. As you probably heard, 6 of the council members voted for the ordinance, and 1, David Carson, voted against it. So we had Jerry Lee Anderson voting for, David Carson voting against, Steve Fields voting for, Jessica Forsythe voting for, Farisha Khan voting for, and Vanessa Kritzer voting for, and Melissa Stewart voting for. So all these people voted for this ordinance. Now, I observed 3 problems here. The first problem was that this was a ordinance that retroactively changed people's contracts, which is against the Constitution of the United States of America and against the Constitution of the state of Washington. Secondly, it was an ordinance that was really designed to try to contravene the laws of the state of Washington, even though the state of Washington very explicitly says that rent controls or laws that control rent are prohibited at the city and county level. And third, although I have no proof, it has come to my attention that one of the voting members was in fact involved in a rental agreement of some kind and did not recuse themselves or inform the city council that they were in a rental agreement and that they might benefit from the outcome of this vote in some way. So now let's take a look at the post-mortem that occurred about a year after this ordinance was ratified.
Tonight, we're going to introduce the staff report to update council on outcomes of the tenant regulations that were adopted last year. On July 19th, 2022, council adopted and passed ordinance number 3091, establishing a series of regulations governing the relationship between tenants and landlords, which went into effect on July 30th, 2022.
One landlord reported that security deposit limitations is causing them to be more rigid in qualifying new tenants and rejecting potential tenants that previously might have been accepted. For example, a landlord might have taken a riskier tenant with the assurance that they could recoup a higher deposit if the tenant defaults, but they can't do that now. One landlord cited concerns about the tenant's ability to pursue legal action after the tenants had vacated the unit as a way to avoid paying damage costs to the unit and suggested a cure from legal action for the landlord once a tenant had moved out. Landlords were notifying tenants of rental increases in excess of 10% because of the murkiness of forecasting 120 to 180 days in advance. Additionally, some property management companies cited an increase in administrative costs due to the rules and staffing, and those costs were passed on to tenants. Finally, one item that all landlords and tenants that I spoke with agreed upon was the need for greater information and dispute resolution resources. Suggestion that staff would like to make is including statewide approach to tenant protections to address this current confusion and lack of consistency between jurisdictions, and so that the City of Redmond would lobby for tenant protections as a statewide level at the next session. So in conclusion, I would like to thank all the landlords, tenants, and stakeholders that I spoke with. This is a really challenging topic.
Councilmember Fields?
Thank you, Mayor. I recall last year when we were talking about this and talking with people in the community, there was a concern about the so-called mom and pop renter or landlords, and that they would basically take their properties off the rental market, sell it, move on. Do you have any information or any data on those types of properties and landlords?
We unfortunately do not have any data because we don't require rentals to be registered with the city, and so there's not a concrete way. I can say with some of the small landlords that I talked to that they expressed frustration with the changes. It is something I continue to hear, but I don't have any data to back that up.
Which sort of leads me to a follow-on question, and I think you've already answered it, but in a lot of your discussion, there's a lot of anecdotal conversations, and that's great. I mean, that is information. Are we looking at ways to measure compared to other jurisdictions that don't have tenant protections? Did our rents go up greater than some of those other communities? Are the other economic pressures equal? I mean, trying to isolate a single ordinance is probably a real waste of time, but it would be interesting to know how we compare to other cities.
Yeah, I did not look at that because of so many of the I wouldn't feel comfortable saying that I think our rents went up X amount compared to Bellevue because they didn't adopt tenant protections and we did, kind of correlation, but I think it could be something we could look into.
Great, thank you.
I'm definitely in favor of us studying adding the ability to break the lease early if a rental amount is above a certain amount, supportive of us looking into legal assistant and ombuds, making sure that those guidelines about renter protections is in our lease packets that go out. I know there's some city information that landlords have. So I'm definitely interested in us updating our renter protections with inclusive of those things. But I'm just like Mr. Fields had brought up, I'm interested in knowing, did this actually have an intended consequence that we wanted, which was to be able to keep people housed in our community? And I'm not sure we have enough data to know that yet. But if there's anything that that we can glean from this ordinance, I would love to hear that, as well as studying the regional price fixing tools that are used and what we can do around that issue as well. If landlords raise their rents, knowing that they had this bigger timeline, because that's what we heard from a lot of folks, was that a lot of landlords, that they would have to raise it due to unforeseen, not knowing what the 6-month landscape looked like, and somehow extrapolating out if that did cause people to actually have to leave our community.
I see what you're saying. To validate, what I did hear from landlords is that they did raise it the highest, as high possible as they thought. Again, we don't have data or track that kind of data. It's dependent on what they're telling us in terms of this anecdotal. So they'd say yes. At the same time, if we hadn't have passed it, would they have raised it 25%? I can't say.
We don't know.
Maybe yes for one property, no for another.
It'll be interesting to continue the conversation.
Yeah.
Question was, is there a way to get feedback now if we did a retroactive to ask? For example, if I'm a landlord and I was planning on a 10% increase, and because of this 3091 regulation was implemented, I now needed to increase to 15%. Do we understand what the impact to the market locally has been because of this regulation? What I heard was no.
I don't think so.
Okay.
And I would say that I did not get that specificity from landlords, like 10 to 15%.
Right.
They just said what they thought it might be, and I think that would be different for every person.
I would agree with that logic for sure.
So to summarize, back in 2022, the city of Redmond was influenced by a lobby group called ARCH to implement Ordinance 3091. This ordinance, among other things, was designed to prevent landlords from raising the rent, at least for periods of 120 or 180 days, depending on whether the increase was more or less than 10%. At the time, the inflation rate was around 10%, and property taxes in King County had increased by as much as 30 to 40%. Ordinance 3091 altered existing leases between landlords and tenants, even though the Constitution of the State of Washington states, "No bill of attainder, ex post facto law, or law impairing the obligations of contracts shall ever be passed." The ordinance also appears to be illegal according to RCW 35.21.83, which states, no city or town of any class may enact, maintain, or enforce ordinances or other provisions which regulate the amount of rent to be charged for a single-family or multi-unit residential rental structure. According to my sources, at least one municipal officer had an interest in a contract that was altered by this ordinance. In other words, they were in a lease and may have stood to personally benefit from the outcome of the vote if the outcome of the vote was in their favor. However, no member of the council disclosed their interest in the contracts that were altered by the vote on the ordinance. I'm particularly concerned about this last point because when I raised this concern, I learned that while they were aware that at least one person was involved in a lease, they decided not to take any corrective action, such as invalidating the original vote and scheduling a new vote. Finally, it seems pretty clear that the City of Redmond's council members do not have a significant amount of experience on the topic of landlord-tenant relationships. They are also working with very little in the way of real data that they can rely on to guide their decision-making efforts. Despite this, they rushed out an ordinance in 2022, ignoring the sage advice of Councilmember David Carson to use good process when making important decisions. And that had many unintended consequences. To create affordable housing, the most important thing that government can do is to reduce the risks associated with being either a landlord or a tenant. If we want to increase the amount of affordable housing on the market, we need to ensure that the rules are consistent across the state and they aren't constantly in a state of flux. Unfortunately, when city ordinances are hastily created by well-meaning but insufficiently wise city council members, and no corrective actions are taken at the state level, you end up with a complex regulatory environment that will scare away many of the smaller landlords. This leaves renters with fewer options. They can either rent from a large corporation, which is generally armed by a well-educated legal team, or they can find a place outside city limits to live.